Good morning, everybody. Thanks for joining us today for Greater Nashville Realtors real-time topics on understanding the new FinCEN rule. My name is Trevor Garrett. I'll be moderating today. I serve as the Secretary Treasurer of the Board of Directors with Greater Nashville Realtors. I'm also a broker and co-owner with Bradford Real Estate. Today, we are joined by Jared Wyatt with Wagon Title. Jared is originally from Northern Kentucky. He graduated from University of Alabama and then attended law school at Northern Kentucky University. After law school, he joined Fidelity National Title Insurance as an underwriting counsel, handling commercial and residential real estate transactions throughout Southeast Tennessee. Jared is a licensed attorney here in Tennessee, enjoys playing golf, and is with Wagon, which we thank Wagon for also being one of the sponsors for Greater Nashville Realtors, allowing us to put on great events to support our membership. So today we're here to understand the regulatory changes with the U.S. Department of Treasury's Financial Crimes Enforcement Network, FinCEN, that has new reporting requirements for certain residential real estate transactions. I'll hand it on over to Jared to share what we need to know.
Thank you for the introduction, Trevor. Yes, again, my name is Jared Wyatt. I'm an attorney with Wagon Title, and we're here to discuss the new FinCEN rule. I have some slides, so I'll share my screen here real quick. Here, let's go with that. And we're going to get underway. So this rule, the FinCEN rule on real estate reporting requirements, went effective March 1st, 2026. As you'll see, there's a little footnote. We are currently on hold. Even before March 1st, 2026, there were all these talks. Oh, we're going to implement some new rules for reporting, and then they kept kicking the can. Further on down the road, we got to March 1st. It went in place for, we'll say, roughly 2 to 3 weeks, and now we're back on hold. So let's figure out what's going on. First, the Financial Crimes Enforcement Network, FinCEN, has issued a final rule to curb money laundering in the U.S. residential real estate market. This rule requires reporting on non-finance transfers of residential real estate. A residential property from where entities or trusts are purchasing the real estate. Again, went into effect March 1st, 2026. However, due to recent court rulings, we have to hit the pause button once again. So let's touch base real quick on why we're hitting the pause button. So my former employer, Fidelity National Financial, first filed in Florida to request an injunction to pause, stating that the Treasury Department had overstepped their authority under the Bank Secrecy Act. Unfortunately, Fidelity was struck down there. So, the court ruled, said, "Now looks like the court in Florida said, looks like that the Treasury Department is acting within their rights as stated under the law." Now, there's always court cases going on all across the country, as we all know. So there was a second case in Texas. And this one is Flowers Title Company, LLC versus Besant. In this one, the Treasury Department, or the judge, issued a nationwide injunction holding that FinCEN had exceeded its statutory authority under the Bank Secrecy Act. It states, while the Bank Secrecy Act allows for FinCEN to require reports on suspicious transactions, the agency failed to prove that all non-financed or all cash transfers to entities or trusts are inherently suspicious. Court found that routine transfers to LLC or trust for liability or tax purposes are not categorically suspicious enough to trigger such sweeping surveillance. And kind of to dissect that a little more, when reviewing the court case, the judge ultimately said, well, why should the public do the government's work if there is not just such abundant suspicious activity going on with transfers of vacant land or residential property. Again, the overarching goal is to curb money laundering from bad actors. All right. So now you may be thinking, well, what are we doing right now? There's an injunction, meaning we're going to pause everything. Well, in the Texas ruling, it clearly stated that while this injunction is in place, and then further, it was FinCEN confirmed through an announcement that nobody has to report or gather information while the rule is on pause. Now, this is good because it was a bit of a question mark initially of if an injunction were to be filed, what would people such as title agents or people purchasing real estate need to do? Would this be, well, once the injunction gets lifted, we have weeks or even months of information to report to FinCEN retroactively? But now, as I put here, reporting persons are not currently required to file real estate reports with FinCEN and are not subject to liability if they fail to do so while the order, aka the injunction, remains in force. I always like to put the common terms translation: no reporting or gathering of information is required at this time. Again, we're back in a holding pattern. But while we're talking, it's still important that we should understand the rule because of, one, the injunction could be removed by a higher court, an appeals court, or even the Supreme Court if it continues to get appealed further on up the chain. This rule could get the injunction could be removed, and we could be back into reporting requirements under this rule, or vice versa. Maybe they just strike it completely, which wouldn't be a terrible thing. But I will say it's still important to know because this helps us understand, what the rule is, what other interests in real estate there are, what threats we have, and also for the real estate industry really to grow and explain and advocate of why we need to do things of this, or maybe why we don't need to do things like this. So that was a long-winded way of saying, let's dive in and kind of peel back the layers of what the FinCEN rule actually is. So the rule itself requires you to report the beneficial ownership of the LLC or the trust of the person purchasing the land. But let's start with step one. The question is going to be, does this apply to me? Well, if all three of these things apply, is the property a 1 to 4 family house, condo, townhouse, co-op, or vacant land for residential use? Whenever I present this, I always like to say vacant land 3 times because, you see vacant land, a lot of people will just check the box on commercial and they'll kind of wipe their hands and say, we're good. No, vacant land will qualify for this unless it has fallen directly within a commercial zoning and was not always in a commercial space. So if they're purchasing lots in a residential neighborhood, this would apply. Second, is the buyer a legal entity? Is it an LLC, corporation, partnership, or a trust? All those are business entities or legal entities other than a natural person. Is the transaction non-financed? Is this a cash deal? Is this seller finance? That's a big one because some people originally thought, when the idea of this rule coming about, thought that seller finance transactions may get you around a reporting requirement. Now, it is you are required in a seller finance or a non-bank slash private loan, similar to seller finance, but maybe it's a different entity. Maybe it's a business providing a loan. There's a couple of different really weird nuanced situations, but so if all three of those situations, if you check the box on all three of those, yes, you have a reportable transaction. Okay, so let's move on. We'll say in a hypothetical, we have checked the box. So now what needs to be reported? First, entity trust information, full legal name, tax ID. We need the beneficial owners. We need a name, an address, an ID for any individual owning 25% or exercising substantial control. An example of that is in some LLCs, you may have a minority owner being the managing member of an LLC. That's a very common situation that at least I see in my day-to-day dealings. You may have, say, Jared owns 10% of the LLC, so I wouldn't qualify under that 25% plus requirement, but I was the managing member. That would qualify as exercising substantial control. We'd also, moving on, we'd also need the payment info. How is this person purchasing it? Are they dropping a whole suitcase worth of cash? Are they wiring it? Are they giving us a massive check for this land or this house, etc., as well as the financial institution involved? Now, if you're getting a suitcase full of cash, it's kind of hard to find the financial institution involved, but there'll be other ways to report that information. And then also the property info. Realtors are, I always like to say, realtors and real estate professionals are always great providing the addresses. Legal description, that's my job as an attorney in title companies. That's our job. So take a deep breath. I'm not going to be sending you an email or sending you a text saying, hey, send me the legal description. That's my job. All right. So we know what needs to be reported. Now the question becomes, who is responsible for reporting? And I love this little flow chart because 3 out of the 4 here is just different ways of saying me as a title company. Because all of us here have done real estate transactions. And so I always ask the question when I'm presenting here is, here's the hierarchy. So it's kind of number 1, the first person to report is our closing settlement agent. Who is that? That's me. Okay, cool. Well, let's say that I fail to do it. Next in the transaction, the preparer of the closing statement. Again, who is that? That's me. That's your title company. And third, the person / entity filing the deed. I'd say 99.9% of the time, that's also me. Now, the fourth, this would be different. The title insurance underwriter. This is my former employer or other underwriters. So Fidelity National Financial, First American, Old Republic, Stewart. Those would be the fourth. So it has this small little ladder. If first person fails to do it, then you go to second, third. Where I was rambling on to say, 3 out of the 4 is essentially the same person in most situations. That's just kind of what I'm trying to get there is every once in a while you'll run into somebody else will file the deed. It could trigger in Tennessee the seller's title company, or if we have a split closing. So just keep those things in mind. And then my last thing is, one thing you will not see on here, or on the initial, there's a much longer list of the hierarchy of the reporting person. All the way down at the bottom is the realtor or the real estate brokerage. If you have reached that point, there are a lot of people failing to do their jobs. I can rest you assured there are a lot of great title companies here in the state of Tennessee that have implemented some really great processes for this rule change. So again, take a deep breath. We're not asking realtors to file this information. Now the question I get asked a lot is, okay, how about some exceptions? Do we have exceptions to the reporting? Because, you're saying every single cash transaction involving an entity, that seems a little overkill. Well, you bet. We've got some exceptions. First one is pretty self-explanatory. Transfers to natural persons. You have a seller selling to Trevor. You have a seller selling to me. That's perfect. There we go. No reportable transactions. We are purchasing as natural people. No issues. Again, we're focusing on LLCs, corporations, trusts, partnerships, etc. Finance transactions through a bank or credit union with anti-money laundering programs. So that's your I will say it's a very overwhelming majority of banks have anti-money laundering programs. So if you have a buyer who's getting a loan for the purchase of their property, I will say 99.9% of the time you're going to be in good hands. There are a few that do not have anti-money laundering programs, but it's very rare. If you find one, you might as well buy a lottery ticket because that's pretty lucky. And then transfers due to death, divorce, or bankruptcy. Those are kind of what we call as distressed sales, and yeah. So those, you have a transfer due to the sole owner of a property dying. There's a divorce decree. So in the instance of death, we're talking about transfers to beneficiaries of a will or an intestate transfer. Divorce, a divorce decree states that husbands to be divested of title and titles to be transferred to the other spouse solely. That would not require reporting requirements. Or bankruptcy. Sometimes title is transferred to various other entities as pursuant to the bankruptcy order. I am not your complete expert on bankruptcy. So if you run into one of those situations, always work with your title companies to make sure to really hammer out to make sure there's no reporting requirements. And with that, I have reached, we will say, questions, and I will stop sharing my screen, and we will open the floor up to some questions.
Yeah, so you can submit questions, I guess, through the comment features of how you are currently watching this stream, and they'll get passed to us to be asked. In the meantime, Jared, let me, throw out some questions at you. I mean, I guess just starting off, like, you know, I know you're not the federal government, you're just trying to explain it to us, but like, what are they trying to accomplish with this? Like,
That's a great question. And that's something that was really trying to be fleshed out in a lot of the court cases. But overall, it's curbing money laundering. There's bad actors in this world, unfortunately. Not everybody plays by the rules. And it was determined, or there was a study done quite a while ago that determined that one of the easiest ways for bad actors, drug cartels, etc., to launder their money was to buy vacant lots, residential homes, and yeah, it was kind of a really quick and easy way. They could have a business entity where the beneficial owners were shielded from being publicly disclosed, and they were able to buy, a bunch of $50,000 lots in a residential neighborhood and then sell them for 40, 45K. Yeah, they may have lost some money, but now they've got good clean money. Unfortunately, I'm not an expert in money laundering. I don't think I would be discussing here if I was. Uh,
it
but yeah,
sounds
that's
like something out of that Netflix show, Ozarks.
exactly. That was funny when I was talking to one of the counsel with Fidelity National Financial and saying it. I was mentioning it's like, wow, I feel like this is kind of, we're trying to make sure there's no more Ozarks coming, like shows that are going to come out. But yeah, so that's the overall goal. No more Ozarks for real estate.
So let's look, internally as an agent, like
No.
oftentimes our mindset is like title company just handles all of this. Like I got the contract done, title company's gonna take it from there. So why as a real estate agent do I need to care about this?
Yeah, That's great because you are exactly right. As this is the title company's responsibility. As we walk through the hierarchy, who is the reporting person? We went through a lot of different steps of saying it's just the title company and the title insurance underwriters. Um, so the reason why a lot of title companies are saying, "Hey, real estate professionals, we need you to know about this," is because we are not the person driving the deal. And so your client, Trevor, may be, why is the title company asking for all this information on my family's trust? We're just looking to buy property and put it in trust, and that's it. So that hand holding, as I like to call it, just to make sure, like, hey, this is a requirement from the federal government to curb money laundering. They're not sharing your non-public information. They just need it to make sure we can get this deal across the finish line. And so it's a partnership. It's, again, we don't need you guys to be experts at it. We just need you guys to. I don't want a client asking you, Trevor, saying, "What's this FinCEN stuff?" And you're like, "Oh, I don't know. Let me get back to you and call my title company real quick." I'd rather you, at least me personally, be like, "Oh yeah, it's this reporting requirement. My title company's really on it, and they'll probably ask you some questions about X, Y, Z." And so just have that information ready. So that's really the goal.
Excellent. And I guess don't want to ask you if you have any fees, but I
Sure.
guess as an industry, like this sounds like more work for the title company. Do you think most companies are raising fees, go charge extra? What do you think's going to happen there for this?
Yeah, I will say, under the rule, FinCEN themselves do not charge a fee for the reporting. Um, so when we submit all the report to FinCEN, uh, there's no fee for us to hit submit. However, yes, the fees are being collected to report this, and the big reason why is that there are some really complex systems that need to go in place. Biggest thing is data security. We are having to collect a lot of data, and as we all know, fraudsters and bad actors are just getting more and more sophisticated. We need to protect that information, and that's required a lot of title companies to really beef up their security. That's probably the biggest reason why there's kind of a reporting fee. I've seen some range from 75 all the way to $200. It really varies on the title company. But remember, this is more time that we have to collect, we have to review, and yeah, and we want to make sure that we keep everything safe.
So I think my next question, like, would be if I'm, I guess, representing a seller
Mhm.
and, you know, I guess what happens like if the buyer just like refuses to turn this information in? Like, is my deal going to fall apart? Is it going to get closed?
Yeah, that's a little bit of a question mark uh, right now. But as a real estate attorney, the biggest thing is that um, the buyer has to provide that information for us to close, and that's just the black letter law of it. It's a requirement in a real estate transaction. But if they refuse, and quite practically, they would be in breach of their contract of failing to close, failing to provide information to the settlement agent to close. Now, that would put the seller in a more, we'll say, a stronger position to say, look, we provided all the information, and we're here at the closing table ready to close. You, Bob, the buyer, are holding this up for not reporting the information. I think the biggest thing we need to do is just prepare buyers. Hey, you want to purchase with a trust, you want to purchase with an LLC, you want to do whatever to take title. That's going to trigger a reporting requirement with the federal government. And again, this is also in the hypothetical situation that um, that the injunction's lifted too. Right now, we're in a holding pattern. We may never see this rule again. And we may be fighting back against this rule as a real estate industry to say, look, we've done this once. We do not want to do it again. If any other variations come about. But yeah, that's kind of the strategy, or if a buyer is being hesitant.
And I will go to note, so Tennessee Realtors did just make an update to the purchase and sell agreements. So RF 401, RF 403, and RF 404 that did add some new language to address this. And those forms are now dated 3/31/26 in the bottom right. So the small edits on line 406, or sorry, 460. So, be sure as you're writing contracts, you're using the new contracts that have the March 31st, 2026 date on those.
Yeah, and that'll put yeah, and that's a great point, is making sure current forms, and ultimately, like I said, the injunction can be lifted tomorrow. It can be lifted in an hour. Um, we don't Nobody here on this call, I don't think, is in control of the fate of this rule. So just being best prepared in that event is absolutely great.
Okay. Um, well, Jared, I think we are through our questions. Do you have any final comments?
Yeah, final comments is, again, we're talking about a rule that's on hold. This is always a great thing. I always say it's always great to be prepared in the event that it gets reinstated. But also, if you're on this call thinking, man, this just doesn't, why did this come about in the first place? It's perfectly okay to be an advocate against this rule. As title companies, my former employer was very against this rule. So don't be afraid to be an advocate and work with your local national chapters of realtors to help advocate against, or maybe you're in favor of it. But again, always remember that title companies are there to assist you. And I'd love to help out anyone on this call with Wagon Wheel. Again, I'm Jared with Wagon Wheel Title. A little shameless plug. But I'm here as a resource if you have any questions, and I really appreciate everyone for allowing me to take some time.
Well, thank you very much, Jared, for your time today and great education for us. Thank you for Wagon Wheel for being a sponsor of the association. Thank you for everyone that tuned in to learn about this rule today. Being well educated is one of the best ways that you can represent your clients. And as always, thank you to our wonderful staff at Greater Nashville Realtors for making this happen today. And thank you everyone for attending this real-time topics.